Guess what? I got a fever. And the only prescription is more cowbell.
I am broken system, broken trust, and I approve this message.
For legal reasons, that's a joke.
I need that money. I really, really do. I need that money. I really need that money. Really need that money. I need that money. I really, really do. I need that money. I really need that money. Really need that money. Really, that money. That money.
Mask on. Fuck it, mask on. Mask on. Fuck it, mask on.
Oh shit. Here we go again.
Welcome back to the show, my friends. If you noticed, we already did one of these earlier today. We were watching Court, but today we've got the one and only Kim Blandino. I actually forgot to download the Kim Blandino dance into my little thing, my video clips that I can play during stream. So forgive me. But yeah, he was in court yesterday for God knows what at this point, if we're being honest. But I watched a little bit over on our Nevada Judges because they decided they were going to live stream it and then put it out as a video, which is a great thing to do. I watched the live stream. So I'll leave their link in the description so you guys can go give them a like and subscribe. But we're here to pitch the third channel before we start. Go subscribe to Reading the Room if you're into that nerd type shit. Yeah, that's really all I got. If somebody can put the link to that in the description or in the comments or chat or whatever, we're going to just do this. I'm playing it a little quick so that it's just shy of 30 minutes. Share this tab instead. Yeah, Uncle Dan's Vintage Vinyl. I watched 10, 15 minutes of it, and I said, yep, Kim's back at it. Kim's doing the same. He's being Kim. I mean, honestly, what more can we really expect? He kind of went nice for a hot second. Sorry, I'm trying to figure out where I want to be at. He was nice for a hot second, and then he just resorted to going Kim Blandino on the court. Hopefully we all make it through. Enjoy.
You have elected not to follow. Sir, interrupt me again, and we're done. As Judge Brown told you 2 weeks ago, you have a very bad habit of interrupting judges, and we do our best to give you the opportunity to speak, but you make it extremely difficult.
And yes, he does have a patch that say he is risen on his ass.
So stop talking over me. Kim Blandino, 26-029-641. All right, we are here on the petition for vexatious litigant first. So I wanted to make a record, talk about how I expect this to go forward, and if there are issues with that, what will happen going forward. So first issue is I received a petition and a supplement from Mr. Jessup. I did not receive a response in reply to that from Mr. Blandino. So I want to put on the record that the controlling case law when it comes to vexatious litigants is Jordan v. State of Nevada, 121 Nevada 44. In that particular case, they do cite some other cases in reference to whether or not an individual doesn't respond and whether or not that would result in the court considering it not be sufficient notice for the four-factor analysis. Specifically, that was In re Martin Trigona. So in that particular.
Also, yes, the last time I covered Kim Blandino, he actually showed up in my comment section, like the actual Kim Blandino who started his own YouTube page. He did indeed show up in my comments, and I'm just like, that's how I know I made it.
Case, the defendant received roughly a 30-day notice of the petition filing and then the setting of the date. It's very similar in time to this particular case, and so I believe that Mr. Blandino has received sufficient notice and made a decision not to file a reply or response, which is absolutely fine. But since the date that that petition was filed, you have filed many documents for both of the cases in the city, which shows the court that you have a great understanding of how that works. So if that was going to be an issue we're going to talk about, just know preemptively it's denied, and the hearing will be going.
I'm sorry, what's tonight?
Sir, if you interrupt me, this will end, okay? You're going to listen right now, and I will give you an opportunity to respond.
I don't know what you said was tonight.
All right, hold on. Today, I'm going to allow you both to talk, and in deciding this, there's not a lot of case law that comes to vexatious litigants, although you've been deemed one before, sir. And when I looked into that, I wanted to get some guidance in reference to how to handle this particular hearing. And in doing so, I'm going to rely on what would be an oral argument standard, which is held in the Nevada Supreme Court. I know this is not the Nevada Supreme Court, and I am not a Nevada Supreme Court justice, but I will combine the arguments to 15 minutes each. You will be given the opportunity, Mr. Jessup, to start. You can reserve time for rebuttal if you would like. And Mr. Blandino?
Can I enter an
No,
objection,
sir,
Judge?
you do not.
Can I
You will
object?
overruled. Thank you. You will be given the opportunity to give your argument as well.
There is a motion to disqualify you, and you
Sir,
cannot
we
do
will get there.
anything.
We will get there in a moment. I have a time clock, which we will go, and you will see the 15 minutes that you have
No,
to be able to.
I'm not proceeding this. He's not a licensed
Sir,
attorney. He
Mr.
can't
Blandino,
represent the city of Las Vegas.
You are not going to talk over me. We've talked about this on the last date, sir.
You
I'm
may-
outlining my expectations. Stop.
We had a conversation last night on Booze and Body Cam about just because you are the loudest person involved in a debate, a court hearing, a conversation, does not mean you're right. It just makes you look like an idiot. And I don't want to call Kim Blandino an idiot because he's not in jail, so he's Kim Blandino. But you're yelling at the judge and the prosecutor, saying that the prosecutor isn't an actual attorney. When, to my knowledge, it seems like the judge and the prosecutor are the only attorneys involved in the situation. So, like, maybe let's not yell at the chief judge of the courthouse. Just
I'm
my
talking,
thought.
or the hearing will end, and I will just determine it based on the motions. Do you understand?
I have not had an opportunity to reply or make a motion to dismiss or a motion to disqualify or to have him declared
So
a
are you
vexatious
saying
litigant.
that you're not going to listen to the way that I handle this? Because if you're saying you can't, then it will end now.
I'm saying right now, if you wish.
See, yes or no, Mr.
we can
Blandino,
shorten
are you
this.
going to listen to what I tell you to do and confine yourself to the way I am as the judge handling her courtroom, or are you not?
I don't think I can answer that question as asked.
Then we can end this and I will make the decision on the motions.
What about the motion? You said we're going to
I
give
will
him a motion to
I can also
disqualify.
issue a minute order in reference to that, sir. I received your 2 new motions and I can issue a minute order as to that. Or you can stop interrupting me and then you can be given your 15-minute opportunity to make the record. So can you control yourself going forward?
I'm not waiving any of my rights, Judge.
Probably
No one's
not.
asking you to, sir.
Yes,
I'm
you
asking
are.
you to comply with the decorum of this court. And if you can't do it, just like any other defendant.
You're trying to
will be
bully me again, Judge.
All right, then it's going to be very simple. As I said, I'll make the record again. You didn't file a reply in reference to the petition for vexation.
I just got the supplement 3 days
Based on
ago.
that, sir, pursuant to Jordan versus State and pursuant to the case that I previously outlined in Ray Martin Trigona, whether or not you make an argument that you should have been given time or in asking for a continuance, those requests will be denied. You've had ample opportunity and you know how the system works. So you have elected not to
Yeah, but you don't.
Sir, interrupt me again and we're done. As Judge Brown told you 2 weeks ago, you have a very bad habit of interrupting judges. And we do our best to give you the opportunity to speak, but you make it extremely difficult. So stop talking over me. Do you understand me? Yes or no?
Yes. But I need time to make a record.
You will be given a record if you can behave, which so far you have not exhibited the ability to do so.
Oh, I'm sorry, you're being serious.
I am being very serious.
Okay, I thought you might have been making a little joke.
There's no jokes here, sir. Stop talking. Mr. Jessup, you have 15 minutes. Would you like to reserve any time for rebuttal?
Yes, Judge, I will be brief in my opening, and I'll reserve the remainder of my time for.
All right, let me figure out how to work this. And you said, I'm sorry, how much would you like to reserve for rebuttal?
I think I'll probably be about 5 minutes, use of time, so I'll reserve the remaining 10.
All right, so, again, you can see this, correct?
And actually, yes, I can see it now.
Is it breaking go now?
Yep.
Okay, Mr. Jessup, have a seat. Mr. Blandino, if you interrupt him, we end.
I need to
Sir,
stand if I
sit
can.
down. We are done talking to you. You'll have 15 minutes
Have a
in a
seat,
moment.
sir.
It's not your turn to
No,
talk.
I'm sorry.
Have a seat.
I have a physical
Have a
problem. I
seat.
need to stand.
Then stop interrupting.
Can I
Is it
stand?
so hard? Of course, but don't speak again.
Hey, that's all I'm
Mr.
asking
Jessup.
for.
Your Honor, the time clock is turned off.
Let's put it in charge. All right, I'm gonna have my clerk do it, and I'll let you know when it gets close.
As I said, my opening statements will be brief. Judge, you made a correct record and noted kind of how we got here, but I want to take just a moment and make sure that is clear. I did file the petition to have Mr. Blandino declared vexatious, and as you noted, he did not reply to that. However, how we got here is based upon actions that occurred in a criminal matter, where we received a criminal complaint that was filed and a case was opened in this court on January 16th. On February 26th, after a couple proceedings, the city attorney's office filed a notice of dismissal, which is proper under Nevada revised statute, NRS 174.085. That process triggers something for the court, and for what I have the responsibility in this court administration, which is making sure cases are processed correctly. And that triggered the ability for us to dismiss.
that beautiful ascot that Kim Blandino is known for. I think I might get an ascot to go with my fancy suits. I'm just going to put it this way. Don't you think, as Kim Blandino, don't you think that even for you, this shit has to be getting old? He's been doing this shit for as long as I've been on YouTube, and I know he's been doing it since before that. Isn't showing up to court regularly, getting all worked up, raising the old blood pressure, isn't it just a waste of time? That's just my thoughts. I would get sick of constantly being in court, arguing with people for no reason.
The action. There's no dispute of that, not even in the defendant's pleadings. However, after that notice of dismissal was filed and the case was dismissed, and Your Honor, in that instance, I don't even know if we have jurisdiction. In fact, I'm fairly certain we don't have jurisdiction over the criminal matter any longer. The defendant filed, at any rate, on March 2nd, a motion to reopen the case. This court correctly ordered and found that the notice of dismissal was proper and the motion was denied. The defendant, since that time, has subsequently filed additional motions and pleadings, essentially asking for some of the same relief or asking for the court to be disqualified. They've been repetitive. Quite honestly, some of them have
I
been...
object. I didn't ask the court.
Overruled, be quiet.
Can I state the reason for my
No, sir.
objection?
Overruled. You will have your opportunity to speak, you can deal with it then. Mr. Jessup, continue.
So, as a part of that effort, Your Honor, the defendant has filed multiple pleadings and processes with the court, and that in and of itself isn't the challenge. The challenge is how repetitive that they are, and they seek the same type of redress that he already has been given, which is that his case is dismissed. He seeks additional redress. However, the judicial system is set up to handle issues of mistake and issues where a person feels they need redress, and that's through the appellate process. This defendant has not chosen to do that. However, instead, what he has done with his repetitive motions and pleadings, as he has come to the court to file documents, has repeatedly interrupted other customers' interactions with the court. In addition to that...
Objection. Has nothing to
Mr.
do with
Blandino.
being vexatious.
I will just note that you have a standing objection for the record. Okay, that will make
But
this
this
a
is
lot easier.
particular.
Stop. You'll have the opportunity to present your case when it's your turn, sir. So please let Mr. Jessup finish.
Failure to
Go ahead,
object
sir.
timely could be fatal.
In addition to that, he's asking staff personal questions that have no...
I'm already tired of Kim Blandino. We're 9 minutes in, and I'm already kind of tired of Kim Blandino. Like, again, yes, you guys reminded me that he basically has nothing else. Just like most of these sovereign citizens, they have nothing else they have nothing but time to do this and waste everyone else's time. But golly, be productive. Go find the meaning of life. Like, go do something. Like, I'm just like Kim Blandino'd out in 5 or 9 minutes. Also, everybody hit the like button. I heard that's what I'm supposed to say.
bearing on the cases here.
Objection, that has nothing to do with
Mr.
litigating.
Blandino, if you interrupt again, you will not have the opportunity to respond.
Also, what I was going to say is, Kim, shut up. Let the prosecutor, court, whatever the hell this guy is, Hans Jessup, great name, strong name, let him say what he's got to say. The judge is going to give you 15 minutes to talk about whatever the fuck you want. You can make your point then. Let this guy get out what he has to get out, and then you can have the floor to address it. Like, they always get mad when you interrupt them when they're making a record, but they don't give a fuck if anybody else is making a record.
I gave you a standing objection, I presume, and the court will just assume that you don't agree with anything Mr. Jessup says. Makes it a lot
I
easier.
have particular objections.
You will have
sir.
an opportunity during your 15 minutes. So stop. Please carry on.
Your Honor, in addition to that, he's taken up court resources and time, asking for copies of his documents and records, which really is just a copy of the documents and records that he's been filing. Since that has occurred, I felt it has been necessary to file a petition to declare Mr. Blandino vexatious. This is something where he has a legal remedy, and that remedy is on appeal. The defendant, since I have filed a petition for him to be declared vexatious, has filed 7 additional civil matters, or 7 additional civil motions, or motions in his civil matter rather, including a motion to disqualify. That motion was heard by Judge Brown. Judge Brown denied that motion after a hearing. And again, the defendant, even as of today, filed a repetitive motion for this court to again be disqualified. He doesn't add new arguments. It is simply a repetitive motion and process, which is meant to delay the actions that we need to do as a court to provide services to the community. We are using our judicial time and resources to address matters that are repetitive and that have been answered, instead of just going through the normal course of process and using his rights to appeal. Even as I indicated, or as you noted rather, he has a pattern of history as a vexatious litigant. He was found to be vexatious at the 8th Judicial District Court, and that was found in 2018. And even since then, as recently as January 2026, additional orders were entered in at the 8th Judicial District Court limiting Mr. Blandino's actions at that court. So, due to his repeated behavior, his continually filing actions even after they have been answered or resolved, he continues to interrupt the court processes, and use judicial resources and time in a manner that is not intended. They are frivolous, in my opinion, and I believe that he should be deemed a vexatious litigant. And I've reserved the remainder of my time for any result.
9 minutes and 30 seconds. All right, Mr. Blandino, hold on. I want to be very clear of my expectations for you during this 15 minutes. You get to make your...
He talked for 3-4 minutes, and Kim couldn't just let him have his 3 to 4 minutes when the judge is like, I'm going to give you 15. He couldn't just shut up for 3 minutes. Also, I want to point out that they're very soft with Kim Blandino. Imagine if Kim Blandino got in front of somebody like Judge Perkins. Judge Perkins would have heard this thing 3 seconds in and been like, yeah, you're going to come see me down here in the courthouse. And then he would have been held in contempt. I just contempt the shit out of this guy.
Record, sir, that is your right. You get to make that record as long as what you are saying is not negative, threatening.
I'm sorry, negative? I don't understand what you mean by
I'll make
that.
the decision of that, sir. If it's threatening, if it's argumentative, if it's degrading, I will stop your argument, okay?
Wait a minute,
I'm the
I
judge.
thought you said
This
it
is
was an
my
argument. I'm allowed to
Sure.
argue.
And I get to stop people when I think the content is irrelevant. And if you touch on any of those things, I will determine it to be irrelevant.
One of those
Do you
things you said
understand,
is
sir?
I can't be argumentative. I'm arguing.
Sir, some of the things you say, certainly in your motions and absolutely in court, can at times be absolutely inappropriate. And Judge Brown admonished you to that fact on the 20th. If you maintain that in my court, I will stop you. Plain and simple. So you can smile and laugh all you like, but it is
I'm
my
not
court.
laughing.
And I
For
have the
record.
opportunity to stop and not listen to things that I find completely irrelevant and inappropriate and threatening. So just know that.
So you made a mistake when you said argumentative earlier.
No, sir, I did not.
I can't
In about
argue?
15 minutes, I will
So
stop
I
you.
have 15
if
minutes to
necessary.
argue my position.
You do, as long as it's none of those things. If it
So I can be
becomes-
argumentative.
If you're going to interrupt me, as I told you many times already, then you don't have the opportunity, sir. So what I'm telling you is if you say anything that's inappropriate or that I deem threatening or any of those things, I will stop you and your argument will end. Okay?
Can I see the timer though? I have trouble picking up the time. You got a battery in there?
I don't. So I will tell you when 5 minutes pass at each time and when you have 1 minute remaining. Does that
So I
sound
don't
fair?
get to see it then.
You don't. You may start now.
All right. This case started with a criminal case. He's correct on that, and he's not disputing that. But the thing is, there's been a first motion to disqualify you, filed by me. You filed no response. You didn't file a challenge. The statute requires you to challenge it or arrange for another thing. In fact, it says that you have to arrange for another judge to hear the matter. And then, as a side note, it says the judge may challenge it, but you refused to do it, and you had plenty of time to do it. So that when I filed to try and get the case reopened or disqualification, I filed 4 separate things. You ruled 4 separate times. KFARR is a key case in that. It says once a motion to disqualify is filed, the judge can proceed no further. And if they're later found to have been disqualified, any order they issued was void. Now, I filed the second motion to disqualify you based on new circumstances, new facts, new grounds, and it was completely unvexatious, if that's a word. And so the situation is that was filed yesterday. You got served because I've been told that the clerk's office, or the clerk's counter, is an extension of your chambers, and the rule requires it to be served on you in chambers, and that's what I did, just as I did the first one. So, as to the first or the second motion, Judge Brown did not issue a written, signed, and filed order. All you're going by is hearsay, in fact, of saying that he denied it. Russ versus Clark County School District is absolutely clear in the second motion to disqualify. And you are committing a criminal act. I am 70 years old plus, and you're not supposed to oppress elderly people. As vigorous as you might find me, I am an elderly person. I am suffering from age and the related consequences of that. In Russ versus Clark County School District, it says...
All right, so we're going to take this a little bit at a time. Erica, for $5, why can't we all just get along? Turns out, uneducated sovereign citizens absolutely hate my guts. Daisy, looking at you. Yeah, they absolutely hate my guts. But yeah, I'm just going to lay this out here now. Kim, if you filed 4 motions to, I don't know, the judge to recuse herself as the chief judge, yeah, I would probably call that vexatious. The fact that you keep doing all of this, I would say, is vexatious. Yeah, he's 70 years old acting like he's 2. Oh, my guy. He's trying to do exactly what he did in his last case, where he's trying to disqualify you. Oh, I'm free to go. And it's like, bro, that's literally not how it works. And that's not even how it worked the last time. So, like, just stop. Maybe it's just me. He's falling into the Chris Ryder mindset where I'm going to try to drag this out as long as possible. And it's like, personally, if my reputation was on the line and I was going to court, I would want it done as quickly as possible to get my good reputation back. But these people are like, nah, we'll sit on it for years, months, whatever.
Clearly that no, well, I'll get to DEBUNKING first. This is from case law. It's DEBUNKING for the state case site versus 8th Judicial District Court in and for the County Clerk. This is a 2021 decision. We conclude that once a motion to disqualify is filed by a party, and I am a party, the subject judge can take no further action in the case until the motion to disqualify is resolved. Mr. Jessup is totally off his rocker when he says, I move to disqualify the court. No, you, Judge. If they put in a substitute judge here, I'm not trying to disqualify the court. It shows his ignorance as a matter of law in that respect. Russ versus Clark County School District, it's worth quoting. It's on page 10 of the second motion to disqualify. And I'm just going to cut to the highlight. Prior to the entry of a final judgment, the district court remains free to reconsider and issue a written judgment different from its oral pronouncement, which means Judge Brown still could be reconsidering it unless I get a written, signed, filed orders of no consequence, which they say here. Here's the big money quote to that. And Russ versus Clark County School District, citation 747, Pacific 2nd, 1380, 1382. An oral pronouncement of judgment is not valid for any purpose. The district court's oral pronouncement from the bench, the clerk's minute order, which you are threatening to issue in this, and even an unfiled written order, that's an unfiled written order, are ineffective for any purpose and cannot be appealed. So even while he says that my remedy is appeal, there hasn't been any final written order on anything because apparently the municipal court, which used to be named a police court, wants to be still a police court, not really a court of record. Because you don't like giving written orders. Matthew Walker, if you viewed the tape, I asked for a written order on his determination. He said, well, we don't really need to do it, but I'm going to grant your request. So that's why when it came over to here, he said it was for calendaring. But then you, sua sponte, said, I'm assigning it to me. And by the way, there never was any arraignment at that hearing. There was never asked for a plea. There was never a plea entered. And neither did you enter any plea. You are just...
Okay, we have a question. We have a question that I think is very relevant, so I'm going to pause it real quick. Let's do 1 for Eric Martin and 2 for Kim Blandino. Who would win in a fist fight? The fake, real, broken system, broken trust for $2. I appreciate it.
Worthy of being disqualified. You said, and you did not, I'll use the Nevada Commission on Judicial Discipline language in this regard. When they disciplined Michelle Levitt in 2015, they said she failed to be honest. In your affidavit, Judge, you failed to be honest. And this is some of the basis for disqualifying you. You say you didn't have any memory of it on February 18th of the interaction we had as prosecutor and everything. Then all of a sudden, on the affidavit that you set forth, is there any way I could get some water? I've got a little bit of cotton mouth.
Keep going, sir.
Okay, anyway, so when you sua sponte asked for that or assign it, there was nothing done as far as an arraignment. So the record is even incorrect on this. These records are really a mess. And so, but the main thing here today is that, again, you're trying to bully and get me to actually waive rights by acquiescence to this farce that is going on here. It's ridiculous. He's not a licensed attorney. He cannot represent the city of Las Vegas or any corporate entity. He's actually engaging in the unauthorized practice of law.
Talk to the court, don't.
I'm sorry, Mr. Jessup is acting on the unauthorized practice of law because it's well established through all the case law that a corporate entity cannot be represented by an individual person. The only person Mr. Hinge Jessup could represent pro se is himself if he was a plaintiff or a defendant in a case. So this thing about just jumping over this again, I mean, you are committing a crime, Judge, right now because you are oppressing me under color of office. The law is so clear. Erica Ballou just finished her suspension. She's left the state now, apparently. She's a district court judge. She did exactly what you did, only she didn't do it 4 times in a row. She had a motion to disqualify and still continued to make rulings in the case. Something is absolutely forbidden by statute, by case law, and now the Nevada Commission on Judicial Discipline has said that proceeding forward, a motion to disqualify is pending, they cannot proceed forward whatsoever. And so when Judge Brown, I agree that he orally pronounced that, but under Russ versus Clark County School District, there can be no, that can have no force whatsoever in law. I am entitled to a written order signed, filed with the court. And furthermore, if I went to, and I intend to, go to mandamus either the district court or the Nevada Supreme Court or some extraordinary remedy, even if I have to get an extraordinary remedy to order this court to file the written filed order, because if I go now with just what you've given me as a record, quote record, which really isn't a record, they would say, hey, we gotta have a written signed order. You can't, what are we supposed to rule on? So we want to answer, we're gonna direct, an order to be written and filed, because all you got is these tapes. They're not gonna look at, ordinarily, they don't look at audio video tapes, very rarely.
Okay, so we're going to take a break real quick because, yeah, it was just over 5 minutes. I think she said it like a minute or two ago, but he just talked right over it. So maybe he doesn't even know. But what I wanted to talk about was he was saying that he's like being suppressed or blah, 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 blah. This judge, out of the kindness of her heart, set a timer for this man to rant for 15 minutes. That seems as if it's the opposite of suppression. That's the opposite of not letting you talk, is letting you talk basically uninterrupted for 15 minutes. Ryan, you should see what the things this guy has done over the last 5 years. It's crazy. It is absolutely crazy. Lord.
Scotty was on the hook for that, throwing that juror book against the wall. That didn't show up on a transcript. So they asked, they granted the motion to have those tapes when he showed that anger, and the jury was intimidated by this. What's my time?
6:25. 6 minutes and 25 seconds.
Left?
Yes.
Okay. So you sitting up there, Judge, your refusal said.
Also, he said something about another lawyer showing aggression towards him, and it intimidated the jury. A lawyer going like this or something is not intimidating anyone. Even if you looked like this at the jury, then maybe that would be intimidating, but I doubt a lawyer did that.
Asked refusal to follow the law. That's why I wasn't laughing, but I'm smiling, and I thought you were telling me a joke because, you say I refuse to follow your directions, You're refusing to follow clear law that a judge just got removed basically from the bench or not fulfilling what the Commission on Judicial Discipline did, and you did it 4 times. You've done it 4 times, and now this represents a 5th. So your position and Mr. Jessup's position is, because I'm trying to get a dismissal without prejudice is not a dismissal with prejudice. There is nothing in that statute to get a little bit to the merits, which I hesitate to do, but I wanted to, at least try and find some reasonable position that you could take. My neck would be under a sword of Damocles for an entire year if I let the motion to dismiss without prejudice stand. And so there is nothing in that statute nor any of the statutory scheme to say that even though a dismissal without prejudice is given, that one can't come back and ask to have it dismissed with prejudice. Nothing in there. There's nothing at all. And so I tried to talk to the city attorney. I was in here this morning to try and talk to him because in the other case, I filed an unopposed motion to dismiss without prejudice because that's another violation of the code that you did. You vacated those orders, you vacated those motions, that I had 4 separate motions I had, and you did not even allow the city to respond in any way, which points up to what my position is, that you want to act as a prosecutor judge up on the bench with a predisposition toward prosecution. Now I know judges come from both the defense bar and the prosecutorial bar, but you do not want to let go of that prosecutorial bar. I've seen you in court, I've witnessed you, and you, even with me now, I'm in charge, you're letting me make a record now only because you have to. In the past, you cut me short. If you look at the citation, if you want to look at that, you had no jurisdiction. All it would have taken was 2 minutes with Matthew Walker, or you to say, wait a minute, there's no municipal code violation charge. It was an NRS statute. Any judge could have said, well, we're transferring it to justice court because you don't have jurisdiction over the Nevada Rights statutes except through the municipal ordinance that adopts those. But that municipal ordinance has to be charged on the citation. Besides which, every signature on that citation, and I've got the pink copy and the original was in your file. That is the complainant's signature promising to appear. Not mine. I signed nothing on this. She's a complainant and she's not an official. She's not an officer. She signed as a complainant. This violates the statute as the complaint has to be filed or citation has to be filed by a law enforcement officer. She's a clerk over at the district court. And coincidentally, and God winking at me, her name happens to be Karen, who is a Karen, if you know the current urban linguistics. A Karen is a meddling person of female gender.
Your Honor, I object to the disparaging comment.
Give it the weight it's due. Keep going, Mr. Blandino. How much time do we have?
How much time?
2 minutes and 32 seconds.
Wow, good. Normally a real court will have some water. Is there any way I could borrow some water from someone?
Sir, keep going.
I can't borrow somebody in the...
Yes, Kim, please borrow my water. I need the Kim Blandino backwash so that I can sell it on the internet. Please. Somebody will add it to their fucking Kim Blandino museum. Is Kim a lawyer? Nah. He's just a man. Karen Blandino. Yeah, again, like I said, 9 minutes in, the same thing holds true 26 minutes in, guys. I'm over Kim Blandino. I'm over him. Yeah, now he's trying to bum water off of somebody who just came to watch court. Like, here, Kim, take a sip of my water. Somebody nailed it. Kim, you're 70 years old. Like, go relax somewhere. My guy, go fishing. Go anywhere. Give him hot dog water. That's gross, but that would be hilarious to see his reaction.
Should have come prepared.
Huh?
Should have come prepared. Finish your
I
argument.
go to the district court, they have water. It's a real courtroom. This is somewhat of a, as I said, he's doing the unauthorized practice of law.
Stop looking at Mr. Jessup.
I'm sorry. He cannot represent the city of Las Vegas or the municipal court, which is a part of the city of Las Vegas. I mean, what you're doing here is just absolutely, he told me at the window that he was prosecuting me. I mean, he was prosecuting me. He's allowed to sit as where an attorney would sit in this matter, or if this was a civil case, he'd be representing himself. But he certainly in no stretch of the imagination can represent a corporate entity. If I tried to do anything like that, I'd be run out so fast with the unauthorized practice of law to make anybody's head spin. And you're gonna allow this because he just happens to be a court administrator? I mean, clearly he doesn't have a grasp on the fact that when you move to disqualify, you don't disqualify the court. You might ask for a change of venue or something, but the disqualification motion is directed at a particular judge for particular reasons. And I did that both with the first motion to disqualify and with the second.
You have 1 minute.
So, you're gonna do what you wanna do, and then I'm gonna go to, I don't have the time to do it, but I'm gonna have to make time. And it's gonna be an incredible injury to me because of this oppression, this criminal oppression that you are doing upon me.
I don't have time for it. I have filed so many. Oh, God. You don't have time, but you filed so many motions that they want to label you a vexatious litigant. It seems like you have all the time in the world. Ryan, yeah, I actually put out a video a few hours ago for members that will be out tomorrow at some point. And I've made like 3 or 4 shorts, and I'm going to continue making shorts probably after this, but I do have some things for members right now. So if you got a notification, it is late. I think I made it at like 3:30.
And you do it with a smile and a smiling face, but that doesn't negate the evil and wickedness behind this. Especially when you have Erica Ballou just coming off doing exactly the same thing, but only one time. You've done it multiple times. Multiple times. How much time?
30 seconds.
30 seconds. Well, no, I wasn't going to address that, and for the most part, I haven't addressed what his summons was, but I have to say, I went to his window, and he said, you can ask to reply on that date of May 6th. So I know it was unauthorized legal advice or whatever, but when normally you get a summons in a case, they say, you must reply or otherwise respond in 20 days.
Thank you, Mr. Blandino. Mr. Tessa, you have 9 minutes and 30 seconds to rebut.
Thank you, Your Honor. I'll be brief again. A couple of things, even here today, I'm not sure the defendant even responded to the petition in his arguments. He really did not dispute the allegations and the statements that I made. His pattern is there.
You have a standing objection to Blandino.
His pattern is there. One of the things I would note, even though he's trying to relitigate a criminal case, this is a petition for vexatious litigant, and that petition is filed in a civil matter, and this court has jurisdiction over civil matters. And so, as standing, I do have standing as a court administrator to help make sure that this court is operating in an appropriate manner. In addition to that, what I would note here is that in this criminal matter, there is a notice of dismissal. It is permissive in law. That does not negate the defendant's ability.
Bitch, you have a standing objection. The judge has said it like 2 or 3 times. Again, just sit down and shut up. The only thing that I'm going to say is that I know that he has a problem with attorneys that represent him. I know Law Talk with Mike has interviewed, drawn a blank on his name. Somebody's going to put it in the chat. He's had that attorney that represented Kim. He's had him on his page a few times. I feel bad for that guy. That guy probably has like PTSD from seeing Kim Blandino in court. So I feel bad if he is labeled a vexatious litigant and they try to give him any sort of attorney to help him or standby counsel. My heart goes out to you. My heart goes out to you.
To go to the appellate process, but continue to file pleadings and motions when there is a notice of dismissal and the jurisdiction of the court is lost is problematic. It creates vexatious. It's not proper procedure. And so for us to continue to have hearings and pleadings and go through the process of adjudicating all of those things when they're very repetitive it takes up the court's time and resources, when I would note that we've increased our caseload by over 100% in the last 2 years. In addition to that, the defendant's pleadings are almost 700 pages all in themselves. Again, all very repetitive in that process. So with that, I would ask that the court does find Mr. Blandino to be vexatious, and that the court would limit his actions and I would even go so far as to say limit the type of pleadings that he can file with the court.
Thank you. All right. So just to make a clear record, the petition was filed under a civil case number 26-029641, which is different than the criminal case that Mr. Blandino has referred to. After that petition was filed, you did file a motion to disqualify me, which was then sent down to Judge Brown, which complies with statute. Judge Brown heard it on April 20th, and he made an oral denial of that motion, which you admitted in your own particular argument. Additionally, you obviously have seen it since you commented on the YouTube video at least 48 times by my count last night. So.
Fuck. Okay, so it seems like, oh God, Kim, what are you doing? You can't comment on a YouTube video 48 times. Now I'm going to have to go try to find this YouTube video because I'm positive it's on our Nevada judges. They record everything in these courts, especially anything that has to do with Kim Blandino. Who's got time like that? Who's got time like that? I'm just so confused. I'm so confused. It seems like this judge knows what she did and is doing everything right. She called you out for being a YouTube whore. Yeah. Kim, don't comment. No means no, bro. No means no.
You've heard it. You have the opportunity to review it if you would like to. I don't believe there's any requirement that must be written in or given to you in a written order for it to be valid, and so it stands as it is, which allows me the opportunity to hear this today.
Look at what, Judge?
I will take this under submission based on the arguments I've heard and the moving documents that I received, and I will issue an order that will also touch on all of the pending motions that were put on hold that Judge Brown did in both the criminal and civil case. We are off record.
All right.
Okay, that's the video, guys. That's all I got for the live stream for today. It did go a little bit quicker because like I said, I sped the video up because I was over Kim Blandino before I actually played the video. Oh, and I opened up my windows and it's freezing dick outside. I'm actually going to go through their comment section real quick to see if Kim Blandino actually commented on this video, which would be absolutely hilarious. Oh, that our Nevada judges, somebody said, what are the original charges? I've lost track. And our Nevada judges 7 hours ago said battery. So yeah, that's, oh my Lord. Okay, guys. Well, I got to bring it back up. I got to bring it back up because I found something that's not the one I want. That's the one I want. I was going through looking for, I need to be in a different spot so you guys can see what the hell's going on. I was looking for this and I found a complete dirt ball and I clicked on it and I said, this sounds like something Kim Blandino would comment on. And sure as shit, we have found Kim Blandino, guys. We have found Kim Blandino. Please don't be that hard on the judge. Pray for her. I will. Is he back to wearing his jacket that he scorched with an iron? It's a modern day classic. So Kim Blandino's in on the joke. Now I got to go to his page. All right, guys, we are on the Kim Blandino's page. 119 subscribers. My man's out here making content and shit. God damn, he's got like every video. Oh, this is where he tried to go get his pal. I might have to investigate some Kim Blandino videos because these are all when he went to go get his Kingdom of Israel passport, which to my knowledge isn't a place. So I don't know where the hell he's getting this nonsense. Oh boy. Kim, what are you doing, man? The fuck are you doing? All right, I'm going to try to throw you guys over to somebody else's page real quick. Oh, man. I'm so glad that I found Kim Blandino again. I genuinely hope that he doesn't find me. I really don't. I don't want him to find me. There we go. I think Doc starts here in like 10 minutes. I'll throw you guys over to Doc for them in the meantime. All right, that's it. That's all I got. Oh, I'm going to go look through our Nevada judges videos and hopefully, I'll find some more Kim Blandino comments. I might put it together a Kim Blandino compilation video of just him saying nonsense. I want to look for that 48 comments. But that's it. All right. I have a video coming out tomorrow, a Lucky Laptop News video. If you guys know, you know, Lucky Laptop News, hate his guts. But I have a video on him tomorrow, just basically being the old man yelling at the sky. I have a bunch of shorts from that stupid Facebook group that I joined to basically get you guys content. Got a couple shorts coming out from there. I might actually take a break this weekend and just work on the third channel because these people are like genuinely pissing me off at this point. Like sitting through Kim Blandino's case right here, I'm about to jump out my window. Like I'm over it. There's just only so much stupidity one man can handle. Also, I'll end the poll. Who would win in a fist fight? Kim Blandino, 29%. Eric Martin, 71%. So that's it. See you guys in the next one. Bye.
You're still here? It's over. Go home. Go.